My lords, it's 950 crores, my lords. My submission is that the issues in both the appeals are completely different. The order which has been challenged before this honorable court and which is listed today questions the order that was passed on the interim application for stay that was filed initially. That was held against me. Thereafter, this honorable court was pleased to grant me an order allowing me to take appropriate steps pursuant to the DTD, which I have done by issuing the invocation notices through defendant number 4, that is Axis trustee. That is the question that is before this honorable court. Among others, is a question of jurisdiction as to whether the trial court had the jurisdiction, because the DTD had an exclusive jurisdiction clause and courts at Mumbai were to hear these matters. The issue that is in appeal, which has now been filed, which is posted before the Honorable Chief Justice, only pertains to the invocation notice. Now, if these appeals were to be allowed...
The submission made when these appeals were sought to be heard before this matter was sought to be heard before the trial court as well, the commercial appeal which is pending, was that it would amount to modification. Kindly see the order, my lords. Kindly see. This is a submission made by them, not by me. It's a submission made by them.
Please,
based on that submission,
that modification is only with respect to these appeals.
Based on that submission, my lords, the order of the trial court is partially based on that submission. Given that situation, that when that commercial appeal comes up, my lords, the submission that will be made there is that because these commercial appeals are pending, that has to be heard along.
No, my lords, if these appeals are allowed, then in fact the jurisdiction of the court itself is found that the trial court had no jurisdiction. My lords, it's 950 crores, my lords. My lords, it's listed on Wednesday before the Honorable Chief Justice there. We're not opposing the hearing. Please, my lords, these appeals would need to be heard because if the question on jurisdiction itself... No, my lords, this will have to be heard separately because if the question of jurisdiction is found in my favor, that appeal itself goes away. My lords, these appeals question the very jurisdiction.
Going there and say that these two are different.
But please see the submission made by them. Please see the submission made by them in the order. Please see. Turn over the last page, madam.
Really, I have no role to play because in these appeals, it's between the debenture holders and the company. Debenture trustee, they have challenged the action taken by me, the debenture trustee, in the other matter. The writ petition, like I submitted, my lord, has become infructuous. Now they have challenged the recent order of the commercial court. And that's before the Chief Justice. The matter had come twice. And twice they did not say that that matter has to be tagged. I have no.
No. My lords, we made a submission. They said, my lords, we made a submission regarding the writ petition because, my lord, they made a submission, not just. Kindly see the, my lords, have produced the order. They've said the learned senior counsel appearing for the respondents.
Submission is being made, say that it should be heard here.
I have no difficulty, my lords, this honorable court hears it. But my lords, that appeal necessarily has to be tagged with this. Because my difficulty is this, my rights as asserted in that appeal, my lords, directly flow from an order passed, an ad interim order passed here. So therefore, my lords, if both the matters are not heard together and a conclusive finding is not given on 4 matters together, then my lords, it will result again in complications.
Please, my lords. In fact, it should have been heard on the last few occasions. Time was sought on various reasons. The only difficulty is that several applications are also being filed before the trial court seeking orders for release of the pledge. Now, the question is if...
What my learned friend is a third set of applications have now been filed before the commercial court and they say these matters are pending and these things. The multiplicity of proceedings, what my learned friend is submitting is if the question of jurisdiction which arises in these applications is decided, then nothing survives. Even the other commercial appeal that they have filed and the applications that they have filed before the commercial court, everything goes. That's what my learned friend
They have not filed an application in a 7 Rule 10. If they had filed an application in a 7 Rule 10, I would fully understand. Orders are passed under 39(1) and 2 in my favor.
My lords, we're saying that these applications, if these appeals are heard and allowed, then that appeal need not be heard because the question of jurisdiction is what is raised in these appeals. We are saying that there is, in fact, the trial court had no jurisdiction because it's an exclusive jurisdiction.
Yes.
Please, my lords, because if this honorable court is to find... My lords, we're saying that these appeals can be heard today, and if a finding on jurisdiction is made finally in these appeals, that appeal itself will go. No question will arise because if the trial court had no jurisdiction to pass the orders, and that finding is made before this honorable court, the question goes away.
What you are saying that this also can be brought there. There is a point of jurisdiction which they have placed.
Lords, all issues can be gone into. I have no difficulty. Insofar as jurisdiction is concerned,
Then that to be heard together, both the
My lord,
this set of
I mean, because ultimately, my lord, all the applications arise from the same matter. Therefore, it is
Please, my lord.
ideally it should be heard. That's why I said when the matter came up twice, this matter has come up today. The other appeal came up twice last week before the
other appeal, my lords, other appeal
they
came
should
up.
have
My lord, that is
ideally
not correct, my lord. Other appeal came up. It did not reach, my lord. We tried to make a mention. My learned chief had to rise for the day, my lords. Couldn't make the mention.
so we'll place it there.
My lords, let our objection be recorded because our submission continues to be that if this appeal is allowed, then the question of hearing that appeal does not arise because the suit itself goes away. No, my lords. In fact, the interim order granted by this court granted me the permission to take the action that I took. So my submission remains that if the question is that court, the trial court had no jurisdiction to pass any of the orders, including the interim order, then everything goes away. The suit, the commercial appeal, the writ petition all fall away by virtue of the fact that the trial court had no jurisdiction to hear the matter and pass orders in the first place. Now, while a 7 Rule 10 has admittedly not been filed, the very contention taken in the objections to the 39(1) and 2 is that the court had no jurisdiction. Now, the question of jurisdiction has been decided by the court only on the basis of fact communications were received by the plaintiff in Bangalore, whereas there is an exclusive jurisdiction clause and the only party who's not a party to the DTD also has its registered office in Bombay. So our submission is that the entire cause of action arises in Bombay. There is an exclusive jurisdiction clause. Therefore, in those circumstances, if these appeals come to be allowed with a finding that there was no jurisdiction, everything falls away.
may I make one suggestion? My lords may record submissions of both the councils that these two matters are here and two matters are there. My lords may place it for orders before the learned Chief Justice. Let him decide, my lord, which matters have to be tagged with what.
Please.
And my only submission is let the matter be posted on Wednesday because the other matter is also on Wednesday. Let some.
My lords, respondent number 1 to 4 minutes.
4 states that 2 appeals.
3, my lords, 3. 20.
Chief.
Only one appeal. Only one.
One appeal and one writ petition. Writ
Yes,
petition
my lord.
number also.
My lord, it's commercial appeal 148 of 2025 minutes.
For the bench decided by the Honorable Chief Justice, these appeals we also listed along with that appeal. That's right. This submission is contested by the learned counsel appearing for the
Appellants in all 3 matters, my lord.
appellants in all these appeals stating that the present stating that the appellants have challenged the jurisdiction of this court
Please, my lord.
for entertaining the present appeal.
Please, my lord.
Hence, in that sense, both are not connected. These appeals are not connected with the appeal listed before the court. It shall be
Instead of saying not connected, they can be independently decided is the right way of putting it.
She submits these appeals can independently be decided. Behold the pendency of the appeal before the bench of the Honorable Chief Justice. It shall be in view of the submissions made, we deem it appropriate to this appeal before the
For directions before the Honorable Chief Justice. Whether those matters have to be tagged or whether these have to be tagged. Like administrative side, let directions be passed instead of posting it, connecting or posting it with those matters. The difficulty is this. I mean, we have some practical difficulty. I'm sure my learned friend also. If whether the matters will reach there is a big.
Oh, that's a
I mean, off the record moment, that's.
If you have big mistake right or place it before the bench. From the submissions made, if these appeals be listed before the bench decided by
On the administrative side is better, Manoj, whether which has to be tagged with
which?
what? Because of this division of years, this
Which would become the main appeal. I think the submission is
24 Malods have
The
the roster. So from 25, the chief, Honorable Chief has the roster.
Or it could be appropriate would be to make, you will make a submission before the Honorable Chief Justice that if the appeals are there, those need to be open.
That's exactly what I said. Last week they should have.
And 19 morning, I'll seek instructions. I'll try and
They
make.
will not say anything.
Please, Manoj.
Yes.
Okay, appropriate would be that they make a submission there, that was also pending. Please.
Because these are first in line. These appeals are the first in line.
But the difficulty is this. Honorable Chief Justice asked, have you mentioned in that court, because the matter did not reach there on the last occasion. Mentioned in that court or not was then it will become a problem for me. Honorable Chiefs were to please. No,
I don't think they have not even attempted making a mention.
Lord, I could not make a mention at 10:30 in the morning for a matter which is listed at serial number 79. Matter reached up to serial number 64, my lords. We were waiting in court.
Tell them what to do.
My lords, whatever, my lords, may please record.
My lords may post these matters on Wednesday before those other matters are on Wednesday before.
My lord, yes, but the difficulty is this, my lord. I am pressing for relief in those other matters.
We're not understanding. We want what is entire difficulty send it there. We are only saying that you would mention it there, and so that these matters can also be called before the Honorable Chief Justice.
My lord, no, my lords, my request is please place it on the administrative side for the Honorable Chief Justice to take a call on which should be the main matter. Whether these matters should be considered as the main matter, should that matter be considered as the main matter?
Then he has to hear the parties. Within our file.
My lords, then
Submission is contrary to what the party in the sentence we say don't need to be heard here.
I have no difficulty either here.
No, not to be heard here. I don't think that's what my
He
understanding.
say independent.
Independent.
This can be heard independently because the question of jurisdiction arises in these matters, not necessarily in those matters.
Assistance is required of the council. Taking a call also.
No, therefore, what your lordships have dictated, only thing is whether it has to be placed on the administrative side or is what my lords have to decide.
Yes.
My lords have noted the submissions.
My lords may just place it on the administrative side, as learned.
We will not practice it there. Who will make the assistance? Who will give the assistance? Who will give the assistance?
Let these matters be on Wednesday, my lord. We will between us, we will see whether to mention before that.
Stay there.
This honorable court, my lord.
Let the matters be posted on Wednesday.
My difficulty, my lords, is on 19th when I press for relief in that commercial appeal, my lords, then it should not. But if I have to mention, no, my lords, the difficulty is that, my lords, let me just put my predicament, my lords. My predicament is, my lord, there is some kind of an oral understanding, my lord, which is being honored till date.
No, I am not sticking to that oral understanding anymore because that was your lordship asked me whether we are doing anything until they file anything as of
now. The difficulty is when the matter comes up on the 19th, when the matter does come up on the 19th, my lords, I should not be put in a position where they say, no, this amounts to modification, because that is a submission which is made, that is a submission which is recorded. Then again, my lords, then the Honorable Chief Justice has to post that matter which is on 19th to a subsequent date, and then it just whole process will get delayed. That is the apprehension.
This and we say that we listed
no, that is what perhaps
That's
therefore I'm saying, my lord. My lords had asked me whether we are doing, as far as the debenture trustee is concerned, your lordships asked me whether we are going to do anything until they file an appeal against that order in the other matter. Now they are harping on that. Now that understanding, I am making a statement today that now that they have filed that appeal, I cannot be bound by that statement tomorrow. That's all I am saying, because their strategy is that tag along these matters with that, they will never reach, and my understanding, my statement stands.
No, my lord, with great respect, that is not that.
They are only concerned with the submission, what we read and what he had did.
Yes.
If you want, then you can argue there also. We adjourn this. You can argue there also about these matters need to be heard for whatever it's worth.
Please place it before court hall.
Please.
We just add that. We said, sure. On the ground of jurisdiction of
Please. Of the trial court, my lord, the commercial court.
jurisdiction of the trial.
Please.
In the suit.
Please, my lord.
Entertain the suit.
And to pass orders on the interim applications.
Entertain the suit.
Please, my lord.
Entertain the suit. And as such, this appeal need to be heard first.
Please, my lord.
And in the point of jurisdiction is not held.
ಇದನ್ನ ಮೇನ್ ಅಪೀಲ್ ಮಾಡಿದ್ರೆ ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ. ಇಟ್ ಬಿ ಇನ್ ದ ಟಾಪ್ ಆಫ್ ದ ಬೋರ್ಡ್.
Not be heard.
Please.
That's your submission.
Please, my lord. Would fall away.
Update shall be these appeals are listed before you. Court number. In view of the submissions made, we need to appropriate to this appeal before court number.
Interim
On
order.
19.
Please, my lord.
My lords have to tag the
We are
Long
not
with-
saying so.
very.
We are
I
not
follow.
saying so. We are only placing it.
Please.
For the court, because all the matters would be before the court. Court will hear you on that. See the point?
Please, my lords. Interim.
Serial number 23, my lord.
Sorry, early in the morning, we took so much of your time.
Yes.
Serial number 23, my lord.